Hello guys, welcome back to the channel Ajay Sharma. So today we are talking about a landmark case, Gurubaksh Singh versus State of Punjab, AIR 1980. That case fundamentally changed how personal liberty is protected in India. We are discussed in detail of the Gurubaksh Singh Sibbia versus State of Punjab 1980, a Honorable Supreme Court judgment that is the very foundation of the anticipatory bail. So let's start. Landmark judgment on anticipatory bail. First of all, what is the anticipatory bail? And it is a legal provision under the section 438 of CrPC that allow a person to seek bail in the anticipation of an arrest on the apprehension of a non-bailable offence. It's a shield, not a sword, meant to protect an individual's freedom from the false accusation and malicious prosecution. Now let's look at the fact of this case. The Gurubaksh Singh Sibbia, a former minister in the Punjab government, the allegation was faced the serious allegation of the political corruption, and the application he and his co-accused filed for anticipatory bail under section 438 of the CrPC, fearing arrest. The High Court's ruling, the Punjab and Haryana High Court dismissed the applications, imposing a restrictive interpretation. It held that anticipatory bail should only be granted in the exceptional cases. A prominent former minister in the Punjab government, he and his associates were facing the serious allegations of the political corruptions and fearing imminent arrest. They applied to the anticipatory bail. The legal question was whether the power to grant anticipatory bail under section 438 of the CrPC should be interpreted restrictively, as the Honorable High Court held, or liability as a protective measure for the personal liberty. However, the Honorable Punjab and Haryana High Court took a very restrictive view of the section 438 of CrPC. They dismissed the applications and stating that the anticipatory bail should only be granted in the exceptional and rare cases. The High Court believed that the granting such a remedy liberally would obstruct the police investigation and created a unfair advantage for the accused. So this brings us the core legal question that was put before the court. Should the power to grant anticipatory bail be interpreted respectively as the High Court held, or should it be interpreted liberally to protect the fundamental rights to the personal liberty? The Honorable Supreme Court ruling and the guidelines. The case went up to the Honorable Supreme Court, and a 5-judges bench delivered a powerful and far-reaching judgment. The Honorable Supreme Court decisively overruled the Honorable High Court restrictive interpretation. A 5-judges bench led by the Honorable Chief Justice Y.V. Chandrachud overruled the Honorable High Court judgment, emphasized that the Section 438 is a vital instrument for the safeguarding personal liberty, and the judgment established several key principles and guidelines. They emphasized that Section 438 is a vital instrument for the safeguarding personal liberty, and that a person should not be deprived of the freedom merely on the basis of a first information report. The court stated that the discretion to grant anticipatory bail is not an extraordinary power but a normal judicial function, and it should be exercised in the line with the spirit of provision. And the judgment laid down the several key principles that are still followed today. So let's discuss one by one. First, reasonable apprehension. The applicant must demonstrate a reasonable belief that they may be arrested for a non-bailable offence. This apprehension should be grounded in the specific and objective facts. The court made it clear that to apply for anticipatory bail, a person must have a reasonable belief that they might be arrested for a non-bailable offence. This can't be based on a vague feeling, or must be reasonable. The apprehension has to be grounded in a specific and the objective facts. For example, a public spat with someone who has a political influence, non-police investigation into a matter you are connected to. The fear of arrest must be real and substantive in the reasonable apprehension. Next, discretionary power. The courts are vested with the discretion to grant anticipatory bail. However, the courts must exercise this discretion judiciously, taking into account the nature and the gravity of the accusation. It's not an automatic right. A court must exercise this power judiciously, meaning they have to consider all the facts of this case, especially the nature and the gravity of the accusation. For example, a court might be more hesitant to grant bail in the case of a heinous crimes like a murder compared to a case of a minor financial dispute. The court weighed the need for the personal levity against the seriousness of the alleged crime. Next, no blanket protection. Blanket anticipatory bail, providing the automatic protection against any offense, is not permissible. Courts must carefully evaluate each case to determine whether the anticipatory bail is warranted. It means you can't get anticipatory bail that protects you from the arrest for any and all the future offenses. The application must be specific to a particular case or a set of related allegations. For example, you can't get anticipatory bail for a corruption charge and then use to the same order to the prevent arrest for a new assault charge. Each case must be evaluated individually. So let's talk about the next guideline. The court can impose the condition for granting bail. While anticipatory bail can be granted, the court may impose the reasonable conditions to prevent the misuse. For example, the court may require the applicant to cooperate with the investigation or refrain from influencing witnesses. The granting anticipatory bail doesn't mean a free pass. To prevent the misuse, a court can impose the reasonable conditions. This might be requiring the applicant to cooperate with the police investigation, prevent the applicant from leaving the country without the permission, and directing the applicant not to the influence or intimidate witnesses, requiring them to report to the police station regularly. And these conditions are ensuring that the investigation is not hampered while the person's liberty is protected. Finally, the court clarify a very important point: filing of an FIR is not mandatory. The court ruled that anticipatory bail can be sought even before the filing of an FIR as long as there is a reasonable basis for the apprehension of arrest. However, if the FIR has already been filed, the applicant must still seek the anticipatory bail before being arrested. The court stated that the anticipatory bail can be sought even before an FIR is officially filed as long as there is a reasonable basis. I'm talking about the reasonable basis for the apprehension of arrest. The purpose of this provision is to protect an individual from an imminent arrest, which can happen even before a formal complaint is registered. Of course, if an FIR has already been filed but the person hasn't been arrested yet, they can still apply for the anticipatory bail. Basically, these are the guidelines for the anticipatory bails. Thanks for watching, guys. That's all for today. If you have found this video helpful, please give it a thumbs up and don't forget to like, share and subscribe. Bye bye, guys.